Good morning, everyone. We are delighted to see all of you here today, despite the really, really gloomy weather it's looking like. We are very pleased to have the opportunity to share with you today and discuss with you issues relating to accessibility and reasonable accommodation for businesses under the ADA. Just a few administrative things before we start and get into our substantive comments. We are beginning at 8. We're going to finish at 9:30. We're hoping to leave time for questions. We'll leave as much as we can. If your question is not answered during our session, please come up to any of us afterwards. We're very happy to talk to you, or certainly give us a call or send us an email. And we would be delighted to talk with you. Restrooms for women are sort of right across there. For men, they're across the way from the reception area. We have this morning a very interesting agenda. As an employment lawyer, I am particularly excited about it. It is fascinating from a legal perspective, but it's also quite challenging, both from a legal perspective and a business perspective, because we all think of, oh my gosh, what does this mean in terms of risk management for our businesses? What does this mean in terms of risk management for all of us as employers of individuals? I would like to introduce our panel members. Mr. Aaron Cannon is with us today. He's just to my right. He is a Chief Accessibility Officer and co-founder of a company by the name of Accessible 360. He is a seasoned website developer and accessibility engineer, and he has a highly specialized background and skills and experiences relative to our topic today, and a vested interest in having the web more accessible to all of us. Mr. Cannon has been blind since birth and has himself used the assistive technology since the 1980s, although you were very young then.
Indeed.
Yes. He uses JAWS and NVDA for both work and recreational use of the Internet. Since the 1990s, he has been proficient in several programming platforms and languages. He has been working in website accessibility since 2007. These years all sound very surreal to me. I can't believe what year we're in now. Aaron became a full-time accessibility engineer in 2011 and leads the audit services for Accessible 360. He enjoys doing accessibility training, which he's done for about 10 years. But particularly fascinating to us as lawyers, he serves as an expert witness throughout the country in national landmark cases involving website accessibility that you'll hear about today. Ms. Michele Landis is to his right. She is CRO and co-founder of Accessible 360, and she's been partnering with Aaron since the early days, as I hear. She leads business development, manages client development and marketing, and strategic partnerships. And she consults on creative digital strategies for nationwide clients. She spends a lot of time working with companies and business associations on how to tackle accessibility issues and how to build inclusive design, and also does a great deal for building the business case for accessibility. She speaks throughout the country on this topic and was recently invited to speak at an event that I now want to go to. I've never heard of it, but now I want to attend. It's called South by Southwest, and she's scheduled to speak on mitigating legal risk in the niche area of technology. To Michele's right is my partner, Steve Helland. Steve is a partner in our law firm in the technology, intellectual property, and internet area, property law. Steve started with us as an employment lawyer. He still admits to this, although reluctantly. And although he has moved to a different area in our law firm, the topic today, both from an employment law standpoint and a technology accessibility standpoint, is near and dear to his heart. After the demonstration by Aaron and Michele of actual accessibility technology, Steve will talk about website and technology accessibility, trends and demographics, some of the key cases that will make you all just sort of, oh, and the outcome of those cases, and he will also provide comments on limiting risk, dealing with risk in this area. I'm a partner here in the employment law group, and I do all things employment law. That's all that needs to be said about me. Just a few comments to give us a bit of an overview before we jump into a demonstration. You will hear during our presentations today about a lot of different federal and state statutes that come into play in this area. The core statute, though, really is the Americans with Disabilities Act, our federal statute. The one thing that folks may not know about the Americans with Disabilities Act is it is huge. It's a huge act, and it's very comprehensive. It actually has 3 parts. For those of you that have attended employment law seminars with us over the years, you've heard a lot about one of the parts, Title I of the Act, that protects employees and provides and has obligations for employers in terms of non-discrimination and affirmative action. But we also have Title II of the Act, which deals with state and local government and accessibility of public services in their arena, and Title III, which you will hear a good deal about today, which deals with public accommodations and services provided by private entities. Again, just by way of a 30,000 feet above sea level, to put us in context, Title I of the Act that you've heard a lot about is the piece that prohibits employers from discriminating against folks based on disability, applies to applicants and employees, and applies to employers, most employers that have 50 or more employees, also to labor organizations and employment agencies. It both prohibits discrimination, but more importantly to the context of our talk today, it affirmatively requires employers to engage in what's called an interactive process with individuals, including applicants and employees, who have disabilities that affect either their ability to apply for work, to successfully obtain a job, or to be successful in their job. So employers under Title I are required to engage in this interactive process with individuals and their health care or mental health provider to determine whether reasonable accommodation is needed, and if it is needed, to provide that reasonable accommodation. Under Title III, which we'll hear about, the basic rule is that this is the title that applies to private entities and public accommodations and services. The basic rule is that no individual can be discriminated against based on disability in the enjoyment of goods, services, facilities, it's very broad, advantages or accommodations in any place of any place of public accommodation. Without further ado, we will turn it over to Aaron and Michele.
Actually, I'm next for a couple slides.
Oh, you are?
Yeah.
Okay.
That's okay.
We will turn it over to Steve for his couple of slides.
All right, good morning, welcome. Thank you, Ann, and thank you, Ann, for, Ann was one of my supervising attorneys when I was a pup lawyer.
And he survived.
There were more than a few missteps. Thank you for not revisiting some of those missteps from me. All right, we're gonna go through a few slides, and here we go. All right, so a couple of intro comments by me. So I began as an employment lawyer, and then I switched to this whole like e-tech thing, and that's where I spend most of my time now. My comments here are going to be kind of general in nature about this new emerging issue of the Americans with Disabilities Act, which, as Ann said, you're probably familiar with from the employment context. It's the same law that also means that many businesses have like ramps that a wheelchair can get in, or accessible handicapped doors for physical spaces. But this new thing's been happening where plaintiff attorneys are arguing that the same Americans with Disabilities Act that makes physical spaces required to be accessible are now applying to digital or virtual spaces, like websites. And so that is a new thing, and we'll delve into it. Although my comments are general, some of you run the gambit here from This is a new issue to you are deeply engaged in this. And I'll say, this is a new and evolving terrain. And so if you've had a different experience or if you've had a comment or if you disagree with what I say, please raise your hand and chime in, because I've learned more from either vendors and consultants I work with like Accessible 360 to my clients all the time. Also, although it is flattering to me when I don't think there are any plaintiffs in this room, I think you're all clients or on the company side. So my bias is I'm a defense-only lawyer. I've given some lectures where I've had plaintiffs quote me back to me in a dispute. And so I'm now going to give the overarching disclaimer where everything I say today is for general information purposes only, and it may or may not apply to your particular case. All right, I think that's, so there's my bias of being a defense lawyer. And so again, if you've had a different experience, let me know. My other bias is that Accessible 360 is not only a vendor that I've worked with, but they're also a client of this firm. I'm friendly with some of the founders, and so I've got a personal bias and interest. So anything I say that's nice or complimentary of them, you should view with extreme skepticism, okay? All right. Now, let's get into some initial substance before we turn it over for the real demo. So how we got here today, we should go back to 2008. And this is where there's a headline which we saw some of in this town where Target Corporation settles with blind patrons over website accessibility. The National Federation of the Blind sued as a class action saying that they were unable to use the Target.com website successfully. And we'll talk more about the particulars of that case later on, but it ultimately settled for $6 million in damages and another $6 to $8 million in attorney's fees. And so I thought back in 2008, I wrote a little article about this. I thought, I'm going to get way out in front of this issue because it's going to explode with such a big, prominent settlement. Nothing happened. It was really very, very quiet from 2000. There's a little bit of government enforcement. The Department of Justice brought some kind of semi-quiet private actions against mainly universities and some cities, but it was quiet from 2008 till 2015. Where are we today? I will say that even in Minnesota, among our larger public-facing clients and companies here, whether it's in, certainly the consumer services, hotels, restaurants, many public-facing businesses, I bet half of all larger Minnesota public-facing businesses have been sued for this issue. You might not know it because a lot of times it's a private settlement, but if you've been sued, if you've encountered this issue through a lawsuit, you are not alone. This is the slide I showed to my corporate colleagues because they don't always believe me when I talk tech stuff. So when I cite the Wall Street Journal, they listen to me more. And this is the headline saying, right, lawsuits surge. So lawsuits really took off in 2015. In 2015, we had 240 federal lawsuits that tripled the next year. It doubled the next year. We had over 2,000 federal lawsuits in 2018. That's on top of some unknown thousands of state lawsuits, on top of unknown tens of thousands of probably private demands that we never even hear about because they never become public. So what happened between 2008 and 2015 when this really began to take off? I'd suggest a couple of things. Most, perhaps interestingly, right, no new law. Usually when you have an explosion in litigation, it's because there's a new law or a new regulation. That actually is not the case here. It's the same old Americans with Disabilities Act. What happened is the Department of Justice had said that they would give us regulations, and as they have for some physical spaces, saying, a door's got to be 38 inches wide and a sink to be accessible has to be, 24 inches tall, or whatever the answers are. So the Department of Justice had said that they would give us specific detailed regulations on what accessibility means in the context of a website and virtual space. Those were expected in 2010, so everyone was just waiting. They're like, we're not going to sue, we're not going to take action, we'll just hang out and wait. 2010 came and went, Department of Justice kicked it down there, just kidding, we meant 2013. 2013 came, just kidding, 2015. 2015 came and the department said, we're still going to push it down the road further. At that point, a group of plaintiff law firms said, we're tired of waiting. We're going to start our lawsuits without getting regulations. So the lawsuits floodgates opened in 2015. Interestingly, to me at least, the law firms that, there was one called Carlson Lynch in Pennsylvania, they kind of started the modern movement. And they, before they got into website accessibility lawsuits, they were the lead plaintiff law firm on accessible ATM lawsuits. So if you now know, right, almost all ATMs have like Braille on the keyboards, and you can plug in a head jack so you can hear the audio. They finished up that round of lawsuits and they moved on to this next subject matter area. Although since then, a giant number of plaintiff firms have become involved. All right, with that, I'm going to turn over to Michele and Aaron to talk about the context, and here's a clicker.
Thank you. All right, I'm driving, Aaron. So what does accessibility mean in this digital age? Steve did a really nice job articulating, everyone knows the physical requirements of the Americans with Disabilities Act, but the simple definition that we like to use is it is the inclusive practice of removing barriers that prevent interaction with websites and apps and also enterprise systems for people with disabilities. So as that relates to your own businesses, one of the easiest things to think about and point to where one of the first barriers of this is often found in perhaps online applications for employment. So Ann mentioned earlier that Aaron uses something called assistive technologies, and JAWS and MVDA are two examples of screen readers. Screen readers are software that is installed in persons with disabilities' own personal computers, right, either a desktop or laptop, and it allows them to access the internet, navigate the internet, and interact with its content and functionality, right? So if you ever hear anybody say that they can put something on your website for you so that if a blind person gets there, they can use it, run from that individual. Because Aaron and anybody else who's blind would never get to a website without their own screen reader software installed. And that's what we're going to demo in a minute. So what's really important to understand about this whole new concept of digital accessibility is it's simply making sure that the digital content is designed, so it's visually designed, and it's also coded to offer equitable access for people who will interact with it through their assistive technologies. A couple other examples of assistive technology would be a headset. If somebody's paralyzed, they might use a iRetinal mouse instead of a mouse like I do. And there's a couple of examples of different switches out there. The one in the bottom right-hand corner of that slide is a sip and puff. So if somebody is completely paralyzed in a wheelchair, for example, or a severe spinal injury, they can actually navigate the internet by breathing. Very fascinating things. I think I was a little loud there from the beginning. So there's 4 types of disabilities that we work with as a court-certified digital accessibility auditing company. They're the same 4 disabilities that are written into our Americans with Disabilities Act, and of course they're visual, physical, cognitive, and auditory. And just as a quick reference point, when Aaron and the team are doing audits, the guidelines have a couple of requirements for audio, and there's a couple of requirements for cognitive. The majority of our guidelines that we're working in are physical disabilities and vision disabilities. So if somebody can't use a mouse, or of course is using screen reader technology like Aaron does. How many people are we talking about? A very large number of Americans currently have a disability. This is an old census from 2000, and 56 million US citizens have a disability. That represents over 19% of our population. 1 in 10 men are colorblind, so that's one of the reasons why design on websites and mobile apps is so important. The Minnesota Wild, for example, red and green, not a good color combo on the internet, so just FYI. Fine on jerseys or sweaters, but not necessarily great on digital formats. 1 in 3 American families have at least one member with a disability. And here's the important thing to understand if you're hoping to sell your goods and services to as broad of an audience as possible, is that the collective spending power of people with disabilities and their friends and families is estimated at over $544 billion. That's the business case, right? So it's not only the right thing to do, but it makes good sense for your business. We're going to do a demo of JAWS. I'm going to jump up to the podium and actually kind of navigate through as you'll listen to Aaron's JAWS screen reader walk through the website. The first tab on this slide says keyboard only navigation. And one thing that I'd invite all of you to do, and I'm happy to do it after we're talking or anytime, but just go back to your own website when you have a chance later today and try to navigate through your website and don't use your mouse. If you see blocks of highlights and you can navigate through and you can use your arrow up and arrow down and you know where you are, then that means that you've had some work on accessibility. If nothing happens, which was probably what will happen because that happens on most websites, then you have an opportunity to improve that digital experience by putting some work into making the content and functionality more equitable for everybody. going to put this microphone right next to you so you can talk.
Okay, perfect. All right, so again, one thing that we kind of mentioned, but I think it's important to reiterate, is that what you're going to be seeing on my screen is, what you're going to be seeing up there on the projector is pretty much what is on my screen. I'm using a standard Windows computer. The only thing unique about this computer is that I'm running JAWS, a piece of software. But otherwise, this is just regular computer, standard keyboard. So we thought we'd, honestly, we just needed a random website. So we chose this one, nothing against these folks at all. Could have been thousands of others. So I'm just going to start at the top of the page and let you hear, first of all, what a screen reader sounds like.
Same page links to the main content.
I should probably slow that down a bit. Sorry.
Slower.
That good, hopefully?
Don't
All
take
right.
it personally. Aaron's not referring to you with the slower.
You get used to listen to that, listening to the speech rate at pretty high.
Job applications, vertical bar, City of Corpus Christi.
So what I'm going to do is I'm going to hit the H key. That's going to take me to the first heading,
City of Corpus Christi, heading level 1 link. Heading level 2 main navigation.
main navigation.
List of sick groups, start search.
All right, I'm going to hit H again.
Breadcrumbs, heading level 2.
That's the breadcrumbs.
List of 4 items, link home.
Home.
V. Link services, V. Link general government. Application process, heading level 3.
All right, so here we've got the application
Land
process.
Or sort of concept land. The information provided by an applicant on the application and other information submitted will be investigated.
So basically, it's just reading the screen. Let me go down here and just show you the application itself, because I think that's probably the more interesting part here.
Land of an application. Thank you for your land. Underline land. Heading level 3, the career site. Land. The careers can see first land. Please click on jobs with us here in returning land. Please click on the and check your app land. Thank you for your land. Visited link. Go to the career site. Right double angle bracket.
Okay, so I want to go to the career site.
Enter. Opening search. Page adding links. Opening search. Open clickable. Left bracket.
Right.
Slower.
Sped up again.
Slower.
Let me, let's just choose a job here.
Table with code type subload category unlabeled 1 button 0 for administrative support. I clickable on mouse over.
Administrative support. Yeah, let's do that. So the problem here, though, is that the screen reader just said administrative support. Well, it said I, which, you kind of get used to that. But Roman numeral 1. But it didn't tell me that this is actionable. So I might be able to click on this with the screen reader. It might not actually even work. Depends on what browser I'm in, what screen reader I'm using, and probably the phase of the moon. Sometimes it works, sometimes it doesn't. So let's try it. Hopefully it'll.
Enter.
The only thing I wanted to add there is when you have links, they should be marked up as a link. You should know by looking at it, if you can see it, that is a link, underlined, kind of the universal markups of that.
Yeah, and that's in the markup itself.
Virtual.
That's not done here either.
Table end.
I'm not sure how it looks, but
Link send to a friend.
so
Table with 4 of welcome. There are no head. Link left bracket register up land. Link home. Link L. Link take land. Link apply now. Link send. Link apply now.
okay, I'm going to go to apply now.
Enter.
That is marked up as a link, so
Press
that's
enter for
great.
forms mode.
So I've got email. I
If
can
linker
go down
reset.
here.
Linker open up.
Need to create a new
If
account.
you don't link to link click here to register. Link
Click here to
enter.
register.
Registration process.
Actually, you need to hold on a second.
I'm sorry.
not going fast enough.
We able to get to the registration page?
Yeah, just hold on one second.
All right, all right.
I have to, wait, are you creating a new account?
Yes. Yep, click here to register is basically what I went to. Sorry.
Go, sorry.
Moving, so this form is pretty good. I can fill this out
Star confirm password edit.
and type in the information. The interesting thing I want to show you here,
Star
though,
first name edit.
is all of these fields are great.
Star last name edit.
I can tell where the first name, where the last name goes.
Combo box. Preferred contact method.
Preferred contact method. I'm just
Edit,
going to go
edit,
down
to
here
blank.
to.
Edit unavailable. Address line 1. Edit. Select button on mouse. Edit. Country clickable.
Now it wants my country, and
Edit.
this is not a standard input field, so it looks like it's got a drop down because there's a select button right here.
Select button on mouse over.
So I can choose one,
Enter. Select button on mouse over.
presumably. I pressed enter on that.
Land. Select button on.
Now I know from earlier that
Edit. Country click.
what happened is that a list of countries popped up. But I can't actually find that. I can't really see that unless I go to the very bottom of the page, which I can pretty much promise you that most users are not going to look down there for that content. So, just little things like that, a user could maybe figure this out. Really depends on their technical ability. I tend to, be a little bit more technical savvy perhaps than the average user. So,
Little.
I can, I could probably figure this out. A lot of others users are very likely to struggle with that. I don't know if you tested the country with a keyboard.
I did. So what's up on the screen now, Aaron? So visually, or some users on this site will get that information visually. And then, the idea here would be that I could tab through this. And it looks like I can, but it's not really obvious, again, where I'm at. Very easy to use with the mouse. What Aaron was saying when he said he doesn't see it on the page and he can't find it is we would help an organization understand how to make this pop-up modal present itself in the normal navigation so that his experience is the same as mine. I can see it right there in the middle, but he has to listen to that whole rest of the page all the way from the top left all the way down to the bottom right and go searching for it. Because the headings are not marked up correctly and this isn't labeled as countries, that button, if we can just improve it a little bit, he could use it as easy as me. As you can tell, he can go as fast as I can regardless, but that is the point about providing equitable access to the information and content.
And I'm just chiming in here
Yeah.
with one side thought, which is as organizations move increasingly to web-based job application and job search methods, right? I think a lot of those tools might not even submit an application, or the person can't submit unless they've completed all the fields. So Aaron's inability to complete a single field like country, right, is going to stop him or someone else from applying entirely. So you've just blocked now all visually impaired users from even submitting an application.
And then this part down here in the bottom is where during our audits we find a lot of trouble, even if they get this right. Actually choosing a file, like attaching your resume, that's kind of the next barrier right there. So we want to make sure that he can do it because he could be faster than me, right? Aaron had a couple of interesting experiences when we first met. He's overqualified for many, many development jobs, right? And just when he was showing me JAWS and kind of how this whole thing worked, he would go out and try to apply for entry-level development jobs. And he couldn't even fill out the application, and he's incredibly overqualified, right? Forgotten more code than most millennials will ever learn, right? Anyway, that is the JAWS demo. And again, any of the keyboard demonstrations or anything like that, please ask questions later, and we're happy to ask questions at the end. But I'll toss it back to Steve right now. Thanks.
Thanks, Michele. Let's see, Michele, can I get the clicker?
Sure.
Excellent. All right, this is a legal and legal-related CLE, so let's talk about, see if I can expand this. What does the law actually require? Because I find this is an area, too, where there are a number of myths, or you'll just see things posted like this is what the law says. So let's go back to basics. The slide up here is a picture of the Americans with Disabilities Act being signed by President George Bush back in 1990. Some folks, when we had our current administration, thought that the disability laws were going to be non-enforced or go away. And in fact, the Americans with Disabilities Act has enjoyed widespread bipartisan support historically, so I wouldn't expect it to go anywhere. What does the law actually say? Focusing now on Title III. Again, a lot of folks are familiar with Title I, applicable to employees of businesses of a certain size. Title III of the Americans with Disabilities Act applies to public accommodation. So I'm actually going to read, right, that Title III prohibits no individual shall be discriminated against, we'll talk about what that means, on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any place, and I'm going to circle place, of public accommodation by any person who owns or leases that facility. Well, let's drill deeper. What is a public accommodation? That is, I'll say short, the statute actually defines it. It's most public-facing businesses, right? Hotel, restaurant, stadium, movie theater, library, health club, hospital, lawyer's office, health clinic, bowling alley, government offices. So really, if you do business with the general public, you probably fall under the definition of a public accommodation. Here's a subpart of that statute. And just to make sure that most, like I say, most businesses are covered, there's a subpart that says, right beside, hospital or other service establishment. And that phrase has been used by a number of plaintiffs to try to grab in really most businesses. All right, well, what is discrimination? Discrimination includes failure to make, quote, reasonable modifications in policies, practices, or procedures to make a good, service, or item available unless the modification would fundamentally alter the nature of the good, service, or privilege. And that quote is directly from the statute itself, from the Americans with Disabilities Act. That definition, along with this part, right, which is discrimination is failure for the website or business owner to take steps necessary to ensure that no individual with a disability is excluded, denied service, or otherwise treated differently because of the absence of auxiliary aids and services, unless those steps would fundamentally alter the nature of the good, or unless there's an undue burden. Undue burden is a defense. So the way that a typical complaint or lawsuit looks is that the visually impaired or hearing impaired plaintiff says, you failed to make a modification to your website that would allow my JAWS screen reader to function properly with it. So I encountered blockers, I couldn't fill out certain fields, and that's not just in the employment part of it where you might apply for a job, it's any part, right? So if you go to, I'll take target.com as just the example from earlier, right? If you couldn't click checkout, in the checkout basket, the person would say they were discriminated in their experience as a consumer of trying to buy goods or services from that website. In addition to the Federal Americans with Disabilities Act, let's talk about undue burden for a moment. So undue burden is a defense, and that has come up mainly in the physical realm of Title III, right? That if you are a small, let's just say you're a small dental office, and to create a ramp to get into your building, it would cost $1 million. And that to like a small solo practitioner dentist would be an undue burden. And that defense is successful sometimes. In the context of a website, I have not, that's been argued a number of times, but modifying the website I have never yet seen argued successfully in a published court opinion. It's one of the cases where it was argued was the Winn-Dixie case. They're a grocer and pharmacy down mainly in the southern United States. Estimates to fix their website in that lawsuit were $37,000 to $500,000 from different experts. And the court said, whatever the range is in there, doesn't matter, not an undue burden. Now, Winn-Dixie was a giant business, so I'm not saying that this defense is dead. I'm just saying for most businesses, it has not been argued successfully.
They also had just implemented a points reward system by American Express that cost $6 million, so the judge didn't really think that that was too much to spend.
There you go. In addition to the Americans with Disabilities Act, which has certain thresholds that Anne and her team know probably better offhand than I do, there is also state laws that kind of mirror elements of the Americans with Disabilities Act. In essence, they prohibit discrimination by private entities that serve the general public, and including discrimination on the basis of disability. So even organizations that might not meet the revenue or employee threshold are probably covered under a similar state law. Here's just an example from California's Civil Code. But virtually all states have an equivalent. When you see a complaint or a lawsuit, they typically cite multiple different statutes that prohibit discrimination. So the Americans with Disabilities Act is far and away the dominant statute cited. Others include the Rehabilitation Act. This applies, Section 504 applies to all entities that receive federal government funding. So if you are a hospital, a school, university, or other organization that receives government funding, you also have a separate right prohibition against discrimination. The Affordable Care Act, the ACA, Section 1557, that particular subsection requires effective communication with individuals served by organizations covered by the ACA. Most of the cases in this space involve translators in clinics, hospitals, and emergency rooms, like language translators. But it also arguably applies to websites and other technology tools that provide communication. Interestingly, I've never actually, so because there are all these lawsuits, but they typically settle early, and they settle for less than it costs to litigate. And because of that, we have actually a very limited number. So there's a giant number of lawsuits, but we have a pretty limited number of final court decisions on the merits. And so we still remain in a substantially gray area on a number of questions. One of the things that has been argued at the complaint level, but a court has not decided on, is if you actually don't have an accessible website or tech, are you potentially disqualified from receiving ACA dollars? That has been an argument brought by some class action plaintiffs, but those cases, not surprisingly, right, the hospital or healthcare provider organization didn't want to roll the dice on their tens or hundreds of millions of ACA dollars, so those cases settled early on. Section 508 is the one case, is the one area where there actually is the most clarity of what is accessibility, what do I concretely need to do? So Section 508 applies, though, only to government websites. So if you're the Environmental Protection Agency and you've got EPA.gov, then it doesn't just say you can't discriminate on the basis of disability. It says you must follow these specific guidelines. And these are important. WCAG, Web Content Accessibility Guidelines. I give you a website link later on in the materials. Version 2.0 AA. Okay, those are about 10 or 12 pages long, and then there's additional supporting materials around them on the website that describe specifically what you would need to do to make your website accessible. I'll give two very basic examples, right? They're the same examples that everyone uses. One is that you have what's called alt text behind a photo. So right now, if a screen reader user encounters a photo and no one has done anything, I don't know, Aaron, can I ask you, if I had written nothing behind, for alt text behind a photo, what would the screen reader say when it encountered that photo?
It would basically try to guess, and that could mean a random string of letters and numbers. It could mean it reading the file name of the image, which is, something that is not always helpful. So it really varies. Sometimes you won't even know the image is there. And if there's pertinent information in that image, obviously that's a problem.
Okay, so whereas, right, if you've entered alt content, and let's say I'm a website selling sweaters, you might say, I have a photograph of man wearing green V-neck sweater, okay? So that's an example of alt text. Another example would be keyboard navigation, because of course if you are visually impaired, you can't see where the mouse is on the screen, right? So you're navigating through by tabbing and arrowing. So those are just two of the examples that are covered in the Web Content Accessibility Guidelines.
One thing we see quite often, for example, that's could really cause a user to be able to make a pretty strong argument for missing out on some of the key aspects is a lot of times companies will put offers, current offers, coupons, and so forth inside of those images. And so without those being handled properly, again, that's a situation where you could actually miss out on something, potentially, some amount of value.
Sale on shoes.
We've got a question here, a comment from Luke.
Yeah, just a quick question. You had said the government have specific requirements, and you referenced the EPA. Does that also cover state and local government websites?
So I think that in section 504 is what covers state and local, but I'm not. I'm always terrible on the spot of like exactly which number ends and starts where. But I'll just say this: state and local government websites are for sure covered by a prohibition against discrimination. And if we go back to actually the ADA Title III, the definition of a public accommodation, like government building or government facilities are covered there. So you're going to get there to the same result one way or another. All right, what else can we have? For those folks who are providers or vendors in this room, right? One way that accessibility, that I'm seeing this more and more often is now, is a contractual requirement that your company has signed a contract that says, right, vendor or you will comply with all applicable laws and regulations in providing services and deliverables. And they might specifically call out that you will provide, if you're providing tech, that the website or app or whatever, by the way, when I say website, that's really a shorthand. It's shorthand for almost all technology-based communication tools, almost always websites and apps, okay? So when I say website, think app as well. And so sometimes contracts will require you to meet these specific WCAG standards. So here's tip number one, because I want to have practical takeaways for you. So my first tip is that if you're a customer, right, which I guess most of you probably are of technology services, like if your company has an employment portal built for you so people can apply, or a general website built for you so that people can shop your goods and services, make sure that as part of that contract with your vendor, there is a clause that explicitly calls out that what they provide you will be accessible, meet the ADA and state requirements, and will also explicitly meet this WCAG 2.0. And I think one of the very, very last slides, I have sample language. That's not the only way you could say it, but I wanted to, like, again, give people a concrete example. So towards the very end, there is that clause. And I know that because these are slides and handouts, the type is really tiny. If you can't read it or it didn't turn out well, email me and I can like email you a Word version of that suggested language for your vendor contracts. My biggest case so I've defended about 50 to 70 of these website accessibility cases in the past few years. And my actually biggest case 2 years ago was not a disabled person suing a website operator or a company. It was a giant bank in the southern United States that had bought a fancy new website from a web developer. And the bank got sued by a disabled person. And the bank had a great contract, and the contract favoring the bank, and the contract said, hey, website developer, you're going to build us an accessible website that complies with all laws, and if there's any lawsuit, you take care of it, you cover it. And so in fact, that website developer had to pay for the lawsuit to make it go away, and did north of $500,000 of free repairs, okay, to the website because they had a great contract. So there are concrete results to this. So that's tip number one. Tip number two is if you have been sued, or if your company is sued or received a demand letter, before you just call your insurer or call your lawyer, as a part of calling your lawyer, the other thing you want to do is you want to pull your contract with your existing web technology developers and see if they already have in there a term or rep and warranty that says that they'll comply with all laws and what they deliver to you, because you might be able to shift the risk and cost of this. What does a typical complaint look like? So these lawsuits tend to look very similar, and we'll kind of walk through some of the common elements. I picked this one almost at random. On any given day, there's probably about 5 to 10 federal lawsuits filed. So I tried to pick one that was not in Minnesota. So this is from about like 2 months ago, filed in New York. By the way, again, so litigation activity, there is one repeat plaintiff in Minnesota, anyway, since we're here in Minnesota. That person's been suing government entities and has sued about a half dozen of them. Those cases are all pending. But because the internet, of course, is kind of global and national, businesses get sued, typically, even if you're a Minnesota business, right, or a regional business, you can get sued in New York, California, Pennsylvania, Florida. Those are the main jurisdictions. And so that's where we're usually defending or settling these cases. And so it's not just going to happen in your own backyard. So the plaintiff. So this was filed about 2 months ago in February. The plaintiff was Aretha Crossan. She is a high volume plaintiff, and most of these cases are brought by a small number. There's probably 50 individual plaintiffs that are responsible for the thousands of lawsuits. She, in the past 18 months, has personally filed 47 lawsuits, and the law firm she works with has filed close to 100. She's visually impaired. About 90% of the cases I see are brought by visually impaired plaintiffs. About 10% are brought by hearing impaired. The hearing impaired plaintiff typically wants videos content to be captioned on your website. So again, like an easy example of what should you be doing, what should your organization be doing to comply. If your videos are not well captioned, and I know that sometimes YouTube will auto caption, but if you looked at that right, the reliability of those auto captions is dubious in some cases. So you wouldn't want to count on it, certainly not if your organization is, has important educational information or important health information, et cetera. All right, so what does the complaint do? So the complaint says, I'm a blind or disabled person. I tried to use your website. In this case, it was Heartbeat Health. They are a New York-based heart testing, heart monitoring service and business. You could go in and they attach an EKG to you and you run on a treadmill. So the person went to heartbeathealth.com and was, as Aaron and Michele demonstrated earlier, not able to access a bunch of pages or functionality on that. And therefore, that states a claim under both the Americans with Disabilities Act, Title III, and also New York State disability law. It's styled as a class action. class action complaint. Most of these cases are styled as class actions. But when they settle, and they typically do settle, you're only settling against one individual. So one of the things I have to explain to my clients is just because you settled and you bought peace with this person doesn't mean that you have bought peace on the issue globally, right? And so that some other plaintiff across town or across the country can also turn around and sue you. Among my more prominent clients, I won't name names here, but I'll just say like clients that have very public-facing, consumer-oriented websites, they've now all been sued 3 to 6 times. Okay, so this can be a recurring problem. The remedies they seek are under the ADA. They seek attorney fees. That's the main source of damages. And then they seek an injunction requiring the website owner to fix the problems, okay? And that, whether it's a settlement or a court order, they're almost always requiring you to get some kind of a third-party expert to help you. One of the things that is, I think, frustrating for businesses, and I share this frustration, is that businesses can do things, we'll talk about them a little bit later on, to improve the accessibility of your own website, but it actually is pretty hard for self-help to get rid of all the errors and all the blockers, just because it's hard for a sighted user to simulate what Aaron and Michele did earlier. So you might want to consider hiring an outside tester to actually go through and test. All right, that was I did give my bias disclaimer, right, that you should view everything I say that's nice about them with huge skepticism. So that was one example. All right, let's get into some cases. So we've talked about Target, but I'm just going to do a little further. I should also say, by the way, I was not involved in this case by Target. I'm not trying to pick on Target. I don't know what their website was like back in 2006, 2008. What I do know is that now, actually, their website works really well for the visually impaired, and that I hold them up oftentimes now as a model. They have an internal team of a bunch of folks, including visually impaired folks, so that I've seen actually Aaron in a different demo, right, like went to target.com, and we're like, okay, buy paper towels. And he, grabbed some Bounty paper towels, put them in the checkout cart, grabbed a coupon, put that in the checkout cart, and then checked out like faster than I could go to target.com and buy my Bounty paper towels.
Target hires our former employees, by the way. They've taken 2 of our folks, which is great. They're a great company to work for, so we don't feel too bad.
All right, so the complaint said that Target was inaccessible and violated the ADA. This is back in 2006, the case that kind of got it all going. Target moved to dismiss because they're like, hey, Target.com, that's not a physical space, that's a virtual space. ADA does not apply to virtual spaces. And the court in California said, no, here's the deal. If your website, even though it's a virtual space, has a, quote, nexus or a connection to your physical stores, things like store locations, store hours, what's for sale in the stores, offers in the stores, then the ADA will apply to your website. However, there were some parts of the case where it was just standalone, where the court did dismiss the claims in favor of Target, was where the website was not tied to the physical stores. The case settled after that motion for summary judgment, and like I say, that brings us to where we are today with Target being a great example. They also have good policies if you're looking to, for example, for an accessibility policy or an accessibility statement, you might want to look at Target among other choices because they've done some really nice work. And yeah, there you go. All right, so what else do we know? For key cases, 2015, Netflix. So we've said before, right, that the Ninth Circuit and a number of courts around the country, you need a nexus between the website and a physical location for Title III to apply. But in the case of Netflix, we see some courts are willing to expand it further. Although actually first here we'll say, so the blind plaintiff sued Netflix, and what the court said was, we've previously interpreted the statutory term place of public accommodation to require some connection between the goods or services complained of and an actual physical space. Because Netflix services are not connected to any actual physical place, Netflix is not subject to the ADA, at least Title III, right? They'd still be subject under Title I for employees. So there are some courts that will say, if you're Netflix, if you're online only, this issue doesn't apply to you. However, there is a growing number of courts that say the exact opposite. Frustrating? Yes, it is frustrating. So both the National Association of the Deaf sued Netflix and got the opposite result. Blue Apron was an online-only grocer, and they also were found to have the ADA apply, or Title III to apply to them, even though they're online-only. What's the takeaway for a business owner or business operator to have from this? I would just say this. that even if you are an online-only business, there are some courts in this country that will say that the ADA applies to you on Title III, so this is an issue that will continue to impact you. Domino's Pizza. This was the biggest case probably so far of this year, January 15th of 2019. This case was significant because it took away a defense that we actually had from the trial court level. So overall, plaintiffs are winning the motions for summary judgment in most courts most of the time. There's a number of defenses that we have in particular cases that I'll cover a few of those. But on the global issue, plaintiffs have been fairly successful. That's part of why we see the explosion in litigation. One of the defenses that I was actually very excited about in 2018 was Domino's win at the trial court level. And that was the defense of, let's see, I remind myself here from my notes. Right, it was the defense of violation of due process. And that the law was so vague, right? If those of you sitting here in the audience like, well, what do we need to do? That is a very appropriate reaction because as we remember from the beginning, Department of Justice was going to issue regulations and didn't, telling us specifically what do you need to do. So Domino's argued at the trial court level, this law is so vague. People talk about this WCAG thing, but that's not part of the law. Because there are no regs, therefore, this law is so vague, I don't know what I'm supposed to do or not supposed to do, that under the 14th Amendment to the Constitution, that's a due process violation, because laws are supposed to give you enough of a clue or guidance. How do you follow it? How do you not follow it? If you don't do that, it's unfair. And I hear where they're coming from with that. The circuit court, so that was like the one consistently successful defense that people were going to argue on the defense side. But the Ninth Circuit reversed and took it away. So what the Ninth Circuit said, and this is now law in most cases where it's been argued, is that is the standard a little bit fuzzy? Is it a little bit vague? Yes, it is. But it is not so vague that we're not going to still enforce it. So that defense was taken away. Gill versus Winn-Dixie. This was the first major case that went to a full-blown trial and a decision on the merits in 2017. This was down, as I said, in the southern United States. There's one big takeaway from Winn-Dixie. And so Winn-Dixie was sued. They were found to have violated the Americans with Disabilities Act Title III. And so they ended up having to pay some attorney fees, a couple $100,000, probably most expensively fixed their website. But then the other thing that was interesting in the holding was that Winn-Dixie said, hey, we control some of our website, maybe like what specials are on sale, what the store locations are, et cetera. But here's what we don't control. We use third-party vendors that control our points and loyalty program, and we also use a third party to pay and to check out. Those are different tools. Court said there quite clearly that, thank you for the time, that the website owner, Winn-Dixie, is responsible even for those third-party tools.
Real quickly, the other thing that judge said in that particular case law was that WCAG 2.0 level AA is the standard that they have to meet.
Yeah, so there's a good, so that's a great comment, right? That a growing number, if you got to pick something, the most clarity we have is the Department of Justice, not in regs, but in commentary, and a number of courts have pointed to these WCAG guidelines. All right, I'm going to skip forward to a couple other things. Let's hit employment, okay? Because this is, so you've now heard me talk a lot about how the website is not accessible under Title III to customers. The new development that was substantial within the past year was that we're now seeing it applied to employees. So under Title I, right, the Title I that you're familiar with, that says you can't discriminate against employees. This case was, there's only been a very few of these that have been public. So this was a school employee down in Miami-Dade County, a blind school psychologist. She had to log in which students she had visited with and what the results were into a school piece of software. The school, quote unquote, upgraded its software package. When it did that, it no longer worked for her screen reader. She first began the interactive process that Anne talked about earlier, where she's like, hey, I can't use this. Can you modify the tool? What can we do about this? And the school, I don't know exactly what they tried to do. I don't know that they tried to change the tool. They were stuck with the technology tool. I think they tried to have another employee help her fill out forms. And the court said actually, having another employee help you on an ongoing basis, that is not a reasonable accommodation because there are too many things where that's just not okay. She was too dependent upon this other employee. There were things that you could do through the school website, like apply for a promotion, or maybe the person who's supposed to help her might also be competing for the promotion. So So having just a human helper was not deemed a reasonable accommodation. They paid $250,000 and they're gonna have to fix the website. The other big case for employees that was public is Epic. So the National Federation of the Blind, and they're not just another plaintiff firm, right? They are they're an issue advocacy organization. So in a sense, just like the Target case in 2006, 2008 was a sign of things to come in the future, it is possible, right, and I don't have a crystal ball, but it is possible that the fact that the National Federation of the Blind is shifting gears now and focusing on the employee part of tech accessibility is the sign of things to come. So what the National Federation of the Blind said when they sued Epic, and Epic, by the way, is the largest, if any of you are in healthcare, right, they're the largest vendor of healthcare medical records software in the country. They supply around half of all hospitals and a number of other organizations. So what Epic said, actually, so Epic sued on behalf of blind employees working at places that run Epic, and here I'll read from the complaint. Well, Epic has taken steps to make the patient-facing portions of its electronic health record software accessible with screen reading software so that blind patients are able to access their health information. Epic has not made the clinical or administrative-facing portions of its software accessible to blind healthcare workers. Because the blind individuals cannot use Epic's software on the clinical or administrative worker side, they are effectively barred from employment at hospitals and facilities that use Epic's software. It continues, by selling and or licensing inaccessible software to employers in Massachusetts, and by failing to remediate known access barriers in its software, Epic has introduced an artificial job requirement of sight that has a disparate impact on blind individuals. So this now, and I'm gonna go a couple minutes over. So what this case is really a sea change if there is follow-on activity. It really means that for all employers, the tools that you make available to your employees should, and that could be everything from things like Microsoft, right, which actually Microsoft invests tens, maybe hundreds of millions of dollars in this issue. It's behind the scenes, you just don't know it. But if you, so when you are purchasing tools for your employees to use, and maybe it's an internal database, or maybe it's a specialized tool, increasingly we're gonna see pressure to make those tools accessible. All right, let me now close out with one or two slides on what you can do. So here's the website, the WCAG guidelines. So you have that. You can circle that if you want to go look at it later or show it to your technology colleagues. All right, action items to reduce risk. I'm not going to read all these. I just want you to see that this list is here. Far and away, the most important thing you can do is to audit or take a look at your website or your technology and software tools, and then go and improve them, okay? That is far and away the most important thing that you can do. Then assess and remediate. You can post an accessibility statement. So this is kind of like you've got a privacy policy in terms of use on your website. It is a best practice to have another policy down there at the bottom that talks about if people are having trouble with your website or tech tools, that there's a phone number that they can call or someone that they can talk to. We've talked about human resources portals and vendor contracts, right, that you really should be requiring. Wherever you post your jobs, they should be required to have an accessible tool. Insurance. If you don't already have cyber insurance, that can be a source of a solution. Next slide. Monitor is not just a one and done. I've had clients that have fixed their websites so they work really well, and 9 months later, because of the churn of data so fast on the internet, that they've got new content and it's not accessible. Train your key people. And with that, I think I'm going to stop. Oh, so here's the example. Again, I don't know if this shows up clearly in your slides. This is a warranty that you could put into your material or into your vendor contracts. With that, I'm going to catch a breath and hand the clicker over to Anne.
Thank you, Steve, Aaron, and Michele. That was really fascinating. I am just going to do a very few minutes of kind of not so much wrap up as taking what Aaron and Michele and Steve have so incredibly interestingly relayed to you and put it completely in the employment law context and underscore Steve's comment that he's made pretty directly that, and I will make it even more directly, that I anticipate that if a plaintiff's attorney in an employment law lawsuit sees an angle here, we're going to start seeing these claims as part of an overall employment lawsuit. Just to give you a little context on that in the employment law world, we start with the premise that the workforce and employers and the work environment is decidedly different today than it was in the 1990s when the Americans with Disabilities Act was passed. We've got generational diversity, we've got gender diversity, we've got diversity in background and origin, we've got all sorts of disabilities that are becoming more prominent among our workforce than we saw, at least as lawyers, cases coming across my desk in the 1990s. I have to admit, yes, I was practicing then. We have an incredibly informed workforce. We have incredibly informed applicants, and read, particularly in communities such as Minnesota, we have a very, very creative and experienced plaintiffs bar. We have spillover from the Me Too phenomenon, which goes well beyond the focus on harassment. We've got folks that in the workforce, and we've got applicants that are seeking to join our workforces that have high expectations of companies, of employers, of management. They are much more likely to make internal complaints. They're much more likely to go on social media, as we know. And ultimately, they're much more likely to seek advice of legal counsel in these and other employment matters where they think that they've been wronged. We are seeing in the employment law area attorneys getting involved much, much earlier in the process. And what has been really striking since the Me Too movement came to our attention is that in all cases, not just the harassment cases, the settlement demands are multiples now of what they used to be. We also see the charges that are filed with the federal agencies are, for some reason, in 2018, down from previous years a bit. But we're seeing a steady stream of disability cases, pregnancy disability cases, and retaliation. We suspect in some ways that the number of charges filed is lower because settlements are happening. I was thinking of that as Steve and Aaron and Michele were talking. So we've got workforces and applicants that if they've got an angle, they're going to bring it to your attention, they're going to seek legal advice, and it's going to become one of the many lists of grievances in an internal complaint or a lawsuit. In terms of website accessibility, Title I, which is the part of the ADA where I live and breathe, that applies to employers and protects employees and applicants, it is completely set up perfectly for this kind of a claim. Steve spoke about the tools that you make available to your employees, the tools or the websites that are available to folks applying for jobs. Under Title I of the Americans with Disabilities Act, you are absolutely required to provide a reasonable accommodation so that individuals with disabilities can have equal access to, your website and the ability to apply for jobs and successfully apply for jobs. The one comment that Aaron made is really sticking in my mind, that if a person is unable to do one drop down and they can't submit their application, well, a lot of employers use that as a reason not to consider someone. They don't go further. They'll say incomplete application. All of you may do that yourselves. That's sort of a standard going back decades. Well, they didn't fully submit all the information we asked, so we're not going to consider them. But Title I of the Americans with Disabilities Act is absolutely set up for this on the applicant side and also on the employee side. So if you have an individual with a physical or other disability that impacts their ability to use technology, it will become part of these cases. Steve talked about, I think it's called under Title III, undue burden, right? Yes. Under Title I of the ADA, where I live, it's called undue hardship. And that's a super high standard. So it's a defense to a reasonable accommodation request that the request would be an undue hardship to the organization. Well, what is looked at in terms of undue hardship? how much money the organization makes. So when you see even $500,000, although a lot of these, my experience has been thus far that a lot of the requests don't come anywhere near that kind of cost. But if you have a large organization that's making 10, 15, has 10, 15 plus million in revenue, which isn't, so much, you have huge organizations that make multiples of that. That's just not an undue hardship. So we are totally set up for this. I have had cases involving just these issues over the years, and I have advised my clients to basically make the accommodation because I was convinced that if they didn't, they would be a test case, and that's always the question, do you want to be a test case? And I was fully convinced that they would lose that. Okay, so I'm just going to make since I was told to do so, I'll make some few other comments about other trending areas in the employment law arena in reasonable accommodation. We're seeing tons and tons of mental health, depression, anxiety cases. There was a recent case that was allowed to go forward where a person was terminated because they had an anxiety attack at work. It apparently made people uncomfortable. A supervisor didn't engage in the interactive process and terminated the person, and that case is going forward. We're seeing a lot of activity in the pregnancy area, and these cases involve both accommodation for people who have, need to have lifting restrictions, et cetera, or time off during their pregnancy because they're having a tough time. It also involves discrimination against folks after they come back from leave. There's been some very high-ticket cases in this regard. Walmart was hit recently with a case that was allowed to go forward. It's pending in Wisconsin in federal district court, and it involves apparently Walmart, at least in Wisconsin, at least this is what's being alleged, does not allow or did not allow pregnant workers to have light-duty jobs when it was required because of the progress of their pregnancy, but they allowed others in other circumstances to have light-duty jobs. I have a feeling if that's the true nature of things that Walmart's going to lose that one, or we're going to see a big settlement in that. We see a lot with extended leaves, intermittent leaves. Another trend that we're seeing is, again, I mentioned that in the 1990s, we had a very different environment than we do now in terms of reasonable accommodation. In the 1990s, and actually extending up into the early 2000s, it was considered reasonable for an employer to say, no, you can't work from home. But now, how many people work remotely? I mean, I'm rarely at my desk, so I'm all over the place. You're all over the place. So one of my questions I asked my partners now is, now where are you in physical space? Because it's usually a different country or God knows what. But remote work as an accommodation, we're seeing a lot of. In terms of the applicant stage, I'm not going to talk about hearing and sight impairments because that's been more than adequately covered, but we are seeing requests for accommodation if there's a testing process. I haven't seen it so much with applications and access to the website, but I'm just waiting for those to come in. But folks with learning disabilities, folks that have dyslexia, folks that have other physical or mental health issues have asked for accommodations, at least of my clients. These are cases that we worked out because I advised them to work it out because we weren't going to win under Title I of the ADA. Service animals, this comes up from time to time in the employment law context. It comes up, I think, more in public accommodation context, but just to put a sort of a bug in your ear on that, if somebody requests to have a service animal at work and you're going to deny that request, please call your lawyer.
Is that regardless of the animal? My sister's a flight attendant, and they have like turkeys and...
Oh, yeah. So for
public
accommodations, they actually have some standards. Title VII, well, it's Title VII, not Title VII, the ADA, Title I of the ADA, you can work in some standards into that. It's kind of a longer conversation.
Yeah.
But it doesn't actually have to be a certified animal necessarily. You've got to engage in that interactive process with the provider and everything else. One interesting thing that I've been seeing a little bit of, and I'm wondering if I'm going to see more of, I'm referring to it as language demands. I have a situation that I've had in the last 6 months where an individual with physical and mental health disabilities was requesting accommodation, and at the same time was suggesting that they were being discriminated against, harassed, bullied because of their gender identity, in terms of coworkers refusing to use the pronoun they were requesting. And so it was all mixed in with disability, and it's a very challenging issue for employers. And I put down workplace culture because when there's sort of a cutting edge push for rights to be recognized by certain groups, there's usually a counter push by everybody else, but what about us? And this makes us uncomfortable, and why should we have to do this? So it's an ongoing balancing act for employers. We're seeing a lot of that. This is not to make you nervous, but it's just to put you in sort of a reality check on Title I ADA cases. When these go bad, they go very bad. We pride ourselves in the employment law group that we tend to resolve things before they get. I don't think we've ever had one of these, knock on wood. But the one against Mercedes, the Mercedes company, the $5 million jury verdict, gosh, you read the facts of these cases, and I have to say, I was wondering who was advising them. So their finance director had to have surgery on his throat, and because he had, I think, throat cancer. He comes back from the surgery fully recovered, but he has one of those throat boxes. If you've ever spoken to someone with one, you can totally understand them. You just have to kind of get used to it. Well, what are they? So he wants to go back to his job, which is very client-facing. And what do they tell him? They tell him that that's going to make the customers uncomfortable. And they tell him he has to move to a backroom job, essentially. Well, that didn't go over well under Title I. The other thing we're seeing a lot of are pregnancy cases, and 2 law firms have just been hit. They haven't, this is what's being sought in the class action litigation, $200 million plus is being sought in those cases. And these are some recent settlements in the disability area that the EEOC has had, including a huge one, a $1.75 million settlement by the EEOC. So what are the takeaways here from my perspective? I want to leave some time for questions because I'm sure you have lots of questions for Aaron and Michele and Steve. My takeaway, and it's underscored by what Aaron and Michele and Steve have presented to you, that what is being required here, whichever portion of the Americans with Disabilities Act you're looking at, is a level of creativity and flexibility in approach. I don't think the courts are going to be sympathetic to a lot of these defenses, and this is an overgeneralization. But if you've got a sympathetic plaintiff or a sympathetic set of plaintiffs that are saying, all I want to do is succeed in my job. All I want to do is to be able to apply for a job without spending 5 hours on the system. As Aaron was going through that, I'm thinking, oh my gosh, to do this right, and I'm not as techie as he is, I probably would have to set aside a day to get that thing to work. So courts, agencies, juries, they're going to look for creativity and flexibility in the company's approach. And they're not going to be, my guess is that they're not going to be so much swayed by how much money it costs. So my advice to myself as I'm talking to my clients about this and to all of you is that we should be thinking about this proactively and having discussions about this, and also within your businesses as it applies to you, to proactively look at it before you're calling Steve and saying, help, with what has been served on you. Thank you very much for joining us today. We've very much enjoyed speaking with you, and we welcome your questions. I think some of the questions are being put on, written down, but we'll take oral questions too, won't we, Steve?
Yeah.
Is that okay?
Absolutely.
Okay, so.
Hi. question regarding having these questions with my team members, engaging in the interactive process. Would you be transparent and say, we are obligated to have, the interactive process and come up with, engage in this interactive process and come up with a reasonable accommodation, and, it doesn't have to be what is, maybe your preference. It has to be an agreed upon, and, be transparent to a certain extent, or, I'm not sure if you had touched on any of that. I apologize, I came in late. Or can you perhaps provide any guidance about providing too much information?
Yeah.
Or would you be a little bit more vague in any coaching that you could provide there?
You're never obligated to educate the person you're talking to about the law. And that would be my first, as Steve, I'm on the defense side of these things. So I'm usually defending the company, the board, on these kinds of things. So you're not under an obligation to explain the law to the individual or to tell them what your obligations are under the law. Now, there may be a certain circumstance where your lawyer wants you to do that, but in the normal circumstance, you just should be thinking in terms of, okay, this person has brought a problem to my attention. Maybe they're saying that, they can't fully perform their job duties because they can't get access to a certain, app or a certain part of the technology that they need to do. So you ask them, explain it to me, ask for information. And that's the beginning. So, and why are, unless it's obvious. If it's obvious why they're having the problem, don't say, is it because of X? If it's obvious, and then you just let them know that I'm going to look into this, or I'll see what is possible, and I will get back to you. That's the start of the interactive process. So you know your obligation, but you don't have to tell them, under the Americans with Disabilities Act, I'm required to do what I'm about to do. Because what they're going to want to hear, unless they're trying to make trouble for you, is, I've got a problem, can we solve it? So does that answer your question? Yes. You made an excellent point also, though. Under Title I of the Americans with Disabilities Act, which again is the bubble where I live, the sort of employment bubble, you are not required to provide the best reasonable accommodation. You are required to provide an accommodation that allows the person to be successful in their job. So I don't know, if I ever have this issue, I'm going to be calling these folks for, or connecting my clients with these folks for what the possibilities are in terms of technology accessibility. But if there's a choice between multiple approaches to the technology and one works, pretty well, maybe not perfectly, but works pretty well. Again, I'd want to hear all the facts, but under Title I, at least, of the ADA, that may be okay. Please contact your lawyer when making these decisions, especially about technology, though.
So I'm going to piggyback on that. We've got so many good questions. We're not, I'm sure, going to get to all of them, but we've got, I think, on a number of these, your name and address. We will follow up with you separately. But just on that, on the accommodation piece. So in one of the Epic cases, there was a visually impaired employee. I didn't talk about the employee, and he actually had been a dispatcher at a hospital. The old medical record system said, room 32 is empty now. Can we please schedule, someone up there to clean it or change the bed sheets or whatever? Person had been doing his job as they call him a dispatcher for 15 years. But then the new system came in, Epic, and he couldn't do his job anymore. So it was clearly a case. So they began this dialogue, but it didn't go very far. The reason why I say this is, again, for things that you can do proactively, is tell your procurement people, right, as part of the new vendor selection process, accessibility should be part of it. So that when you're buying new technology, you are having a check the box, is this going to work for visually impaired or other other individuals with disabilities? Because so much easier to fix it on the front end than instead of this conversation where you've got like a one-off later on. I'm actually start reading some questions here. This one, pretty discreet. Is LinkedIn accessible? And I'm going to turn that over to maybe Michele and Aaron.
I'll keep it short. Kinda. You can, they need work, but,
Yeah,
you
they
know,
need
I
work.
can kind of use it, but
Aaron
it's
can use
a
anything.
struggle.
Okay, Aaron can use anything. It wouldn't meet, in my opinion of looking at it for keyboard only, some of the requirements that our other clients do.
Yeah.
One thing I do want to point out is LinkedIn has added an extra feature for those of you in HR. If you want to increase the number of people with disabilities or make sure that you include them in your application process, people can go to their account settings, go under their settings, under privacy, and under demographics. They can choose whether they have a disability or not. So there's thus a new filter on the front end of the interface. When you're searching for people, you be aware that you can add that if they self-proclaim, that you'll be able to search for that.
And that's something that I'm personally not comfortable with, so I would probably never check that setting, but that's good to know.
This next question, I'm going to go over here because I might go back a slide, is a really good question, and it's where if we had more time, we would dive in further. Is the only way to find out if my site is accessible is to use JAWS software or hire an outside law firm. So this, oh, thank you, Ann. So this is hard, right? Part of what is so challenging about this issue is so for audio impairment, right? Do the videos have captions? Okay, that's a pretty straightforward thing. You can look at the, you can look at your website. You can have someone go through and you try a coder, like a tech person, look at the WCAG guidelines and make some of those changes, adding the alt text. But here's the challenge, is that the tool that's easiest to use, which are electronic automated scanning tools, there's a number of them. One of the common ones, and I'll let these guys comment on it in a second. So there's one called Wave, W-A-V-E. It's free. It's pretty good, okay? It is pretty good for what it is. The problem is, and this is from the government, right? They're saying no automated evaluation tool can tell you if your site is accessible or even compliant. Manual testing is always necessary. That is an unwelcome answer, but unfortunately it is. So I think either you can use automated tools. This is a slide that actually I got this from Michele and Aaron. These are some of the common automated scanning tools that you can purchase or get for free, and they're only catching a percentage of errors. I think that they can be helpful directionally to help you make some changes. And I'm here repeating Aaron, something I heard from Aaron and Michele, which is that really Wave is free. There's really the free tools, and the tools that you have to pay for is not that huge. So if it was me, I'd probably try the free one. And then my last comment is, so this is actually, I ran this tool, this is from about 3 days ago, and I ran it on the National Federation of the Blind's website. Let me assure you, the National Federation of the Blind's website is used every day by thousands of visually impaired people. It works great, okay? So that site is accessible. And yet, what does the tool say? 11 errors, okay? So you're getting false positives and false negatives. So this is both the bad side is it could be helpful, but doesn't get you all the way there. On the other hand, if you get a letter from a plaintiff's lawyer saying, hey, I ran a scanning tool and your website has a bunch of errors, guess what? That is not the end of the day. You may still have some defenses. You may be better than you think. But Michele and Aaron, do you want to say
You did a
something
great job.
about
Yeah, you did.
self-help or?
You did a great job. My advice is whether you hire us or whether you hire any firm, any money that you spend on live user or any money that you spend auditing your website or assessing its accessibility should be done with live user testing, because as Steve pointed out, these scanning tools can cover HTML. They don't cover CSS, JavaScript, nothing post-authenticated. So they are very limited. Try a free one and then get some people to help, whoever that is.
Okay, Ann's digesting this, or should I go to a next one?
No, go ahead.
Okay, next question. How does social media play into this if we upload a picture to Facebook, for example, and it doesn't have the alt text behind the photo? So a great question. So here's a couple of comments. One is maybe some good news, right? I feel like sometimes we're always giving just the bad news and whether the glass is half empty. So number one is on the tools that your business uses, there might be some niche ones. Unfortunately, Epic is one of them, and some other smaller tools that are not accessible. But companies like Microsoft, probably one of the more common, and Outlook for email, those companies are investing tens to hundreds of millions of dollars to make those core workplace tools accessible. So there's nothing I would say other than use Microsoft, right? Because that would be one comment. The other is that a number of the big job boards, I know that Monster.com has entered into a settlement, I think, with the National Federation of the Blind, or with a major plaintiff, to become accessible. So some of those big job boards, I don't know if they're all the way there yet. I don't know like their status as of today, but they're working on it. So like your higher risk area is like your own companies, like fredlaw.com, right? If we have a job section, that's probably where your higher risk is. But now going to like the social media piece, I know that Facebook has entered into a settlement and again has like a giant team of people. It's actually hard to retain workers in the space because some of the big companies on the coasts are like a giant kind of vacuum for talent from all over the country. So I think that Facebook is, the platform as a whole is pretty good. Again, I defer to Aaron and Michele as to, I don't know if it's perfect, but if your company has a Facebook page, right? So I've got like the Fredrikson and Byron Facebook page, and I fail to put an alt text behind a particular photo. That's one of those like case specific things. Is failing on one or two photos here or there going to state a claim? I don't think that the ADA requires absolute perfection. It also depends like what the photo is, right? Like on my own website here at Fredrikson, I've had some people call me up and I appreciated it, right? Where they're like, oh, this photo doesn't have alt text. I'm like, well, yeah, but like, that's like a photo of like a lawyer, a fake lawyer signing a document, or a lawyer like shaking hands, right? Like they're ornamental photos. They serve no functional purpose. And so really all the real content on my website, because we're lawyers, right? It's texty. And so even if all my photos, you got like an empty photo, that might annoy you, perhaps rightfully so, but it's probably not going to state a claim. So if you put a photo on Facebook of like your company picnic, I'm going to say, I don't think if you forget to put alt text on half of your company picnic photos on Facebook, I don't think that states a claim. But then I'm wearing my bias, right, as a company management defender.
One other thing I would throw out there is just if you, and this isn't obviously legal advice, I'm certainly not a lawyer, but it feels less risky to me if you are perhaps linking to your Facebook page, sending folks to somewhere that's clearly off of your main company site, rather than embedding your Facebook feed onto your webpage itself. It seems like you might have a little bit better position to argue if it's not actually embedded in your site, but Steve, you can
Sure.
disagree with me if
Yeah.
you want on that.
It's okay.
Just, it feels like it would be less, taking on less risk there.
Right.
Nope, I'm not going to disagree with you.
Just like on your locations page, find a location. Once you go to Google Maps, you're not responsible for Google Maps. Google is responsible for Google Maps. Here's another question. Can you please elaborate on the difficulties with required fields with online applications? Would you recommend removing required fields entirely? No, I would not recommend, as an old UX consultant, no, do not remove the required fields, especially in an online employment application. But I'll take a stab at it and let Aaron kind of finish it up. When you need to label those fields so that it's read to Aaron, as you said, a lot of fields are blank, right? We know what goes in there because we can see what goes in there. JAWS will also make an educated guess. JAWS is very, very smart, so is MBDA. If it's a foreign field and name is first, it kind of guesses. But if you make an error in that, what we would help you learn how to do is put the cursor for the user back up into the form field box where there was an error, type the error out, and also make sure that it's read to JAWS screen reader. So you just think about if Aaron's using it or if I or you are using it, you want the same experience and you want it equitable.
The other thing I would just add to that is that if you, this is more technical, but just have your web developers use standard controls. If they'd used a standard, what's called a select box, which is a standard part of HTML versus that fancy country pop-up thing, they almost certainly wouldn't have had a problem.
Yeah, and someone,
The more you can stick to your standards, the better off you are.
Yeah.
Sorry, go ahead.
I saw another question earlier about drop-down screens. Are all of them inaccessible? No, they can easily be made accessible, and they can be put right into the right navigation. This isn't incredibly difficult. It's just very new to everybody. So you can make drop-downs work. Absolutely.
Ann, did you have a question?
Yeah, I have a couple here. This organization has an employee that has a physician's note indicating that they can't drive at night. And the question is our company liable if they choose to work later and drive in the dark anyway? If this individual has some kind of, I'm assuming they have some kind of visual impairment, they are actually requesting an accommodation by bringing that in. So, you know, you would do what you normally do, engage in the interactive process, figure out what you can do in terms of scheduling, and don't schedule them so that they are leaving and having to drive, you know, when they're not supposed to be driving. It's just like with that, you know, a worker comp accommodation. You know, you manage it so the person knows that they are not to work outside of their restrictions.
Okay, we got a follow-up question right here.
Because she didn't want to work less hours, she never brought it up.
Right, an employee doesn't have an obligation to disclose their disability, but once you know it,
She does, then I have an obligation to stop that.
yeah, you have an obligation to make a reasonable accommodation.
That means I'm reducing her hours to less than 40.
That's a longer conversation,
Okay.
because that's part of the interactive process. I would need to understand your scheduling. That is not always the answer, but it can be if that's the only option.
Should we do one last question? Since I think we're at about 9:30. Ann, do you want to do one last one?
Mine does not have to do with our topic necessarily, so I'll let you
And
answer
so I've
that
got, well, so I've got
question.
one, again, great question. And we're going to stick around for a few minutes and if we don't get to yours. So this question has to do with language interpreters in the healthcare setting and the cost. I'll just say, actually, I have a colleague who we've spoken on this topic together. And so if you let me know who you are, I will refer you to her and she will answer your very specific question. Thank you so much. Have a great rest of your morning.